Hi, I'm Bill Sokol, and I want to tell you about a great new law to help workers in the city and county of San Francisco who work at retail chain stores, okay? This law is going to help you with respect to scheduling and getting promotions and equal pay. It's a really good law, so listen up if you work in any retail stores in San Francisco. It has to be a chain store. The deal is that it's really difficult for people who work in chain stores part-time to have steady, predictable schedules. And so this law that's been passed by the City and County of San Francisco is designed to make sure you actually have some predictability with respect to your scheduling. Here's what the law really says, okay? Here we go. Number one, it applies to any chain that has 20 or more stores across the entire nation, which employs 20 or more people throughout the Bay Area at all its outlets in the Bay Area. So who are we talking about? CVS, Walgreens, Burger King, Wendy's, McDonald's, Ross Dress for Less, Marshalls, Forever 21, Abercrombie Fitch, any chain store with a lot of different stores all over the country, and also at least 20 people working in the Bay Area. Now, if it applies to them, number one, when you get hired, the employer has to give you in writing a good faith effort at what your schedule will be, what shifts you'll work, what days you'll work, how many hours you'll work, and that has to be in writing. You can challenge it and ask for it to be different, and they have to consider your challenge, although they don't have to agree with you. They can say, here's the shifts you're going to work. Now comes the really good part, okay? This kind of ethos that exists right now for just-in-time scheduling, where employers call you 2 hours or 4 hours ahead of time, say, hey, get in, we need you because there's more business or more customers. That's what it's designed to say to an employer. You can't treat people that way who have lives that include something besides work. And so what it says is the employer must give you 2 weeks notice of your shifts. And it has to be posted, either on a bulletin board or electronically, as by email or on a website. It has to include any and all on-call shifts too. And then, if your shifts are going to change, the employer has to give you notice of the change in person, which means either on the phone or by email. And if he doesn't give you at least 2 weeks notice of that change, there can be predictability pay penalties that he has to pay you. What do I mean by predictability pay penalties? Number one, if you're given less than 7 days notice, but more than 24 hours notice, 1 hour of extra pay. If you get less than 24 hours notice, 2 hours of extra pay for shifts of 4 hours or less. If less than 24 hours notice for a shift that was going to go 4 hours or more, you get 4 hours of extra predictability pay. That's a penalty, okay? Now, with respect to on-call shifts, there's the same kind of penalty. If you're not called in for a 4-hour or less shift, 2 hours of pay on call. If your on-call shift is canceled and it was going to be more than 4 hours, you get 4 hours of predictability pay penalty, all right? Now, there are some exceptions, and they're important. No predictability pay penalty to you if your shift is canceled because of threats to the property, like from bomb threats. If there's no shift, they say, hey, don't come in after all, and it's because of public utility failures, water, gas, electricity. If they say, hey, your shift is canceled because of an act of God, storms and earthquakes and things like that, natural disasters, okay, no predictability pay. Or if another employee can't come in and hasn't given the employer 7 days notice of that, they can call you on shorter order, say, hey, come in, you got to fill in for somebody, and they don't have to give you that predictability pay penalty. In other words, if something that happens that's basically beyond the control of the employer, then he doesn't have to give you the predictability pay penalty, okay? And they can still assign you mandatory overtime with no prior notice. Now, employees still have the right, of course, to trade shifts and change shifts and work out shift problems with the employer. In addition to all of this opportunity to have real predictability on your shifts, it also says that part-timers have equal shot at full-time jobs with other full-timers, and you should be paid the same per hour that a full-timer gets for doing the same kind of work. And finally, okay, you have all these rights, how do you enforce them? If you have a problem, you go to the City and County of San Francisco Department of Labor Standards Enforcement, the DLSE of San Francisco. Okay? Know your rights, defend your rights.